very much. So I've done this presentation because I've been drafting terms and conditions for such a long time now, and there's quite often some views that maybe they're not the most important documents. So I thought I would highlight a few of the benefits that terms and conditions can generate for a business, particularly in relation to cost savings, because everybody wants to know that they're getting value for money. So what we're going to cover today, do you want to move on to the next slide, Helen? So what we will cover is, as I've just mentioned, this perception that terms and conditions are not a significant document worthy of investment by a business. In my opinion, they are one of the most critical documents to a business, because if your terms and conditions are properly drafted, they are concise, and they protect you, then they are going to get numerous benefits for your business, and you will derive numerous benefits from them. They may not always be apparent, because quite often they are cost savings that you wouldn't realize you're receiving unless you don't have them in place, but they are nonetheless very important. So I'm going to cover 5 ways that a good set of terms and conditions will help your business save money. So Helen, we can go on to the next slide, please. Thank you. So the first thing that is of note when you have terms and conditions is that they will most definitely help reduce the cost of your sales. If you have a poorly drafted contract, which is wordy, which is long, which is not particularly fair, then you are going to get a lot of pushback on that contract, and you will often hear the infamous words, "I'm going to have to pass it to legal for review." My view is that if you can draft your terms and conditions in a straightforward manner, keep them fair and balanced where you can, and keep them short and simple, you will find that you will minimize the amount of negotiation on those terms and conditions. So when I say that the terms and conditions are fair and balanced, any provisions that can be reciprocal, you need to try and make them reciprocal. So things like your confidentiality clause, your limitation of liability clause, really, that is something that you can easily give, particularly if you are a supplier. You can allow your customer to have a limit on their liability as you do, although you may want to carve out payment obligations from that. But if a customer sees that, they will feel very much more like this is a partnership going forward, as opposed to a one-sided arrangement. I know certainly for some of you that were on the call today, I've done just that, and we have seen a reduction in the amount of negotiation over our contract. I've also advocate making sure that they, when we want to see that they're balanced, whenever you're drafting a supplier agreement, which is the majority of terms and conditions are drafted from a supplier's perspective, that you don't see copious obligations for a customer, but a very scant list of obligations for the supplier. That again gives this impression that it's, as the customer, you're expecting the supplier to provide something, yet you're the one that's giving all the commitments in terms of the contract. It feels very uneven and will inevitably give the customer cause for concern. The other thing that I recommend doing is having a cover sheet on your terms and conditions, which forms part of the contract, which contains all the key commercial provisions that you've agreed with your customer. So if those details are apparent immediately, and the customer doesn't have to hunt for them in the terms and conditions, it will immediately give them a sense of comfort, and they will immediately feel that everything they've negotiated with you is there in black and white in an easy to identify place. And it gives a lot of, they will look at that front sheet, they will flick to the back of the terms and conditions and see that they are, as they would expect, fairly drafted, balanced, and immediately you are going to see less pushback on your terms and conditions. They will likely sign with very little negotiation, and invariably that's going to result in you saving on internal management time in dealing with those contract queries, and ultimately legal fees, because hopefully you are not going back and forth to your lawyer to try and negotiate it, or if you are doing so, it is only on a few key points. So that is, that will that will be a cost of sale to you, and that will help preserve the profit margin that you expect to receive on that particular contract with a supplier. So that is one of the key benefits of having a good set of terms and conditions. One other trick that I do, which I have learned from experience, is it is hugely beneficial, is to format terms and conditions so they appear much shorter. When I draft a set of terms and conditions for a client, it will often number, between 15 to 25 pages long. And a client will say to me, they're hideous, I can't possibly send them out to anybody. But once they're agreed, I format them, I put them into columns, I reduce the font size so it's still legible, but it is much smaller, the line spacing is reduced, and invariably we get them down to about 5 or 6 pages. And that, again, perception that it is a short document, even though, it was a much larger font size, it's going to be much longer, it will give people comfort and, again, prevent them from sending it to their legal team, hopefully, or reviewing it in fine detail. So it's all about perception. So that's the first benefit. So Helen, we can go on to the next slide now, please. So the second benefit that you will receive from having good terms and conditions is enabling you to recover promptly monies that are due to you. Hopefully, that will be the intention. So if you are experiencing problems getting a customer to pay your invoices, your terms and conditions, if they've been prepared properly, will give a clear mechanism to enable you to recover payment of those sums due. There's 2 particular provisions that will help you with this. If they have been properly drafted, your terms and conditions should contain a right for you to suspend provision of the goods or services that you are supplying under that contract. Now, obviously, if you are a critical supplier and your services are crucial to a business, that will be an incredibly powerful right. Now, I don't suggest invoking that right. I suggest mentioning it to your customers that you have got that right there, and you will be further exploring using that right if they don't pay your invoices as soon as possible. You can also include, and this should be in any decent set of terms and conditions, a right to terminate for breach of contract. Now, non-payment of sums due is a breach of contract. Usually there will be a period where you can remedy that breach, 14 days or 28 days, something along those lines, because obviously that is a breach that is capable of being remedied. So you will need to give, again, a customer or the other contracting party notice that you are considering terminating for non-payment. But it is that right that's available, and they're hugely powerful rights, and simply the mere intimation that you are exploring those rights and maybe looking to use them will be sufficient to get the majority of customers to pay those outstanding debts. Normally you would invoke a right to suspend before you'd go nuclear and invoke the right to terminate, but it is just simply the intimation and having the leverage there to say to your customer, we have got this right, so therefore please can you pay us our invoices so we don't have to look at invoking those rights. So again, that should save you time from a credit control perspective, and it will hopefully save you time where from engaging lawyers and other businesses and other professionals to help enforce that debt and get repayment of those sums due from a customer. So it's a very powerful tool, and with the best will in the world, if you have a good set of terms and conditions, it will generate a good relationship with your customer, and hopefully you'll never have to refer to the document ever again. But if you do have to, those rights are incredibly powerful in helping secure payment of debts due. So that's the second benefit. Helen, we can go on to the third slide, please, which is hopefully, yes, that terms and conditions can hopefully reduce the prospect of litigation. Certainly, I went and drafted some terms and conditions for the client of a colleague recently, and that that instruction became around because they had suffered quite a hefty litigation claim against them. And my colleague sat in various of the meetings with me and saw the final draft of the terms and conditions. And in his words, if everybody had those terms and conditions in place, he would be out of a job. So not that I wish to put any of my litigation colleagues out of business, but it does reflect how powerful terms and conditions can be at reducing the chances of litigation. So a well-drafted set of terms and conditions should contain a limitation of liability clause. This means that you can limit your liability to the other contracting party to a reasonable amount. In order for the cap to be acceptable and enforceable, it must be reasonable, and that is specified in the Unfair Contract Terms Act. Your lawyer, whoever is drafting the terms and conditions for you, should be able to provide guidance around what is a reasonable amount. There is a raft of case law surrounding this issue, but generally what is a reasonable cap will be determined by reference to various things, including the value of the contract, the risk attributable to the contract, and the type of goods and services being supplied through the contract. But if there is a limitation of liability cap there, and there is an issue that you have with a customer, the customer, when taking guidance as to whether they have a robust claim, will also be guided around the limitation of liability clause, and that may well deter them if there is a cap on liability which significantly curbs their ability to recover losses from you. It may deter them from issuing legal proceedings and encourage them more to engage with you in order to resolve the matter commercially without necessarily. So again, that's going to save you senior managers as well. And it's also going to help protect you should there be a successful claim for breach against you, because again, there is a limit on how much can be claimed against you. And also there should be a provision in there which says losses that are indirect and consequential are excluded from the claim. This is also important because it is something your insurers will probably be looking for you to do as well. They will probably be looking for you to take reasonable steps to curb any the extent of any litigation claims against you, which can be actioned through a limitation of liability clause. So lots agreed in contract negotiations, and many of you that are on the call today will know that from sheer experience with me, that the last thing it's an interesting one, but any decent set of terms and conditions should have a strong liability clause in there which limits your liability. So the fourth one now. So Helen, if you could hop on to the next slide for me now, which raises a very topical issue of the day, which is force majeure and COVID-19. Very topical. So your well-drafted terms and conditions should include a force majeure provision. Essentially, this is a provision that says if you cannot perform a certain contractual obligation due to an event which is completely outside of your control, then you may be absolved from your responsibility to perform that contractual obligation and potentially will not be liable for non-performance. Now, it is generally considered by most people that COVID-19 is a force majeure event, although there has been some legal debate around this. But primarily it is a force majeure event. It will depend how your force majeure clause is drafted, but certainly in my opinion, it is a force majeure event. And if you were unable to provide services due to a force majeure event, you would not be in breach of contract. However, this is conditional upon certain things. With COVID-19, it depends when you were entered into the contract. If you entered into the contract before COVID-19 became an issue, and probably lockdown, the commencement of lockdown is a good turning point for this, then you can probably rely on your force majeure clause. If you entered into a contract after COVID-19 took hold, and that probably would be again marked from lockdown in my view, then you couldn't rely on that as a force majeure event because it was something of which you were already aware. So, force majeure events can also include flooding of premises, fire, terrorist attacks, those sorts of events that are outside of your control. You are under a duty to notify your customers if your ability to perform a contract is impacted due to a force majeure event. You need to tell them about this, and you need to tell them how long you expect that to last. And you should also be taking steps to mitigate the impact of the force majeure event on your business. So that would be engaging your business continuity plan, trying to set up alternative premises elsewhere. Much as we all did with COVID-19, we switched our offices remotely and all started working from home. So, to the extent that you are able to do that in your business, you should be trying to do that. But again, if you have that well-drafted force majeure clause in there, it means you're not having to rely on other principles such as frustration of contract, which are harder to prove, and it will inevitably help avoid litigation costs and associated costs due to failure to perform a contract. So again, really beneficial clause. It usually appears towards the very end of the terms and conditions. It's usually quite short and sweet, but it has been a highly discussed provision of late, as I'm sure you'll all understand. So we're now on to the fifth and final cost-saving benefit that can be generated from a good set of terms and conditions, which is that they can increase the value of your business. I've worked for quite a few clients for many years now, and one of the key things that I have done with those clients is to help them create good template contracts that are agreed with their customers, such that they have got strong customer contracts in place throughout their business. So when those businesses come to sell and the due diligence process is carried out, those contracts can be produced as part of the due diligence process. That's really important because I have also carried out due diligence exercises where probably the top 5 customers have had contracts that are either non-existent, they are a gentleman's handshake, or they are very poorly drafted. I can assure you, if you produce such contracts in a due diligence process, the strong possibility is that the buyer will look to reduce the purchase price that they are going to pay for your company. They will consider the contracts weak. There is no assurance that those contracts will follow through following the sale of the business, or that they would indeed be enforceable. They may well be terminated following a sale by the customer. So that will create a great deal of apprehension for the buyer, and they will reduce the purchase price payable for your business to reflect that. On the converse, if you have great customer contracts, they're robust, they're enforceable, and they will transfer over with the sale, then that gives the buyer a lot of confidence in your business. I've just had a couple of clients sell recently, having acted for them for a long time, and they were able to produce such things through the due diligence process, which was excellent. And it will enhance the value of your business, most definitely. So it is, really good practice to start from as soon as funds permit you within your business to try and get good template contracts in place, and that will enable you to then at the end of that journey for your business, produce those contracts to customers, to a buyer, to show that you've got strong customer relationships in place. So that's the fifth and final cost-saving benefit that your terms and conditions will generate for your business. So in conclusion, my guidance is to always invest in properly drafted terms and conditions. I've had many people say to me, and often they didn't end up instructing me, that they can simply go onto the internet and pull a set of terms and conditions either from a competitor or, you know, from another business that's similar to theirs. And, you know, in some circumstances, perhaps they may need to do that. But my guidance would be, when funds permit you to do so, invest in properly drafted terms and conditions, because having been doing this for nearly 20 years, I have yet to come across a company who has exactly the same needs as another company when I draft their terms and conditions. Every one of them is different. Every client has different concerns, and they have different things that they need to be covered in the terms and conditions. My other recommendation is to try and keep your terms and conditions fair and balanced to minimise the prospect of negotiation, but also to create the feeling that this is a balanced relationship, a partnership that you're entering into with your customers, with equal, you know, where both parties are equal and both parties will benefit from that relationship. I always suggest presenting terms and conditions in a short format. So this whole perception that they are a short document through the use of columns and clever formatting is really important. And it's remarkable perception, you know, it will avoid, you know, them being passed to the legal team potentially, or, you know, people may read them themselves quickly and just scan them. It's just a perception issue. And also draft your terms and conditions in plain English where you can, to make sure that they're easy to read, easy to understand. And again, this will give comfort to people that you're not trying to get one over them by using complex legal terminology. Train your staff in how to use the terms and conditions. This is absolutely critical. You need your business to be bought into these terms and conditions. Your staff also need to be aware that if a customer tries to impose their terms and conditions on you, that you can push back and ensure it is your terms and conditions that govern the relationship. This is sometimes referred to as the battle of the forms. It's quite a complex issue, but it is important to get people trained in that respect, because otherwise you will have invested a lot of money in your terms and conditions only to find that they're used very infrequently. So train your staff and make sure they're bought into this process. And then finally, just have a cover sheet which contains all the commercial provisions that have been agreed with the parties on that front page. This means that your clients, your customers, will be able to see at a glance what has been agreed commercially. It also makes it incredibly easy for anybody completing terms and conditions for the business to populate the relevant information. They don't have to go and hunt for the information. They don't have to change the terms and conditions, because we don't really want them touching those. It is just a very easy to spot, easy to complete front sheet, which will have all the necessary information. That's my top tips for terms and conditions and my top 5 benefits that they will generate for your business. So we are now able to take some questions. I think, Helen, have we got some questions there?
We've not had any so far. If anyone wants to come off mute and just ask Rebecca instead of typing them in the chat bar, we're happy for that to happen.
I just had one point. It's Helen Rooney here from Gunner Cook. As a litigator, just start my video. As a litigator, I've been talking to clients recently about the benefits of really good terms and conditions. So I think you're absolutely right, Rebecca. I can't stress enough that if you get into a situation where you are in a breach of contract claim, or your supplier, etc., isn't paying, it's so much more helpful to have a really good, strong set of terms and conditions behind you, whether you're on the wrong end of them or not. It really just helps the litigation process so much if you've got something you can rely on and you've got a strong set of terms that you can really use to your benefit.
Yeah, thank you, Helen. I don't want to do you out of a job either. I'll be just say that.
No, it makes it so much easier.
Good, thank you.
Rebecca, Peter Bohm here.
Hi, Peter.
Hi. In your experience, to what extent do insurers look at a company's terms and conditions in assessing premiums?
I'm not sure that they look at them necessarily. I'm not aware of anybody being asked to produce their terms and conditions in order to be able to get an insurance premium. However, when I have looked at insurance provisions for clients and policy documents, I've seen repeatedly provisions in there that say you must have, you know, contract provisions in place which seek to limit your liability. And I'm sure that if a client didn't have those terms in place and didn't have a limitation of liability clause which sought to limit their exposure, that an insurance company would try and push back on a payout, because I'm sure that would give them the wriggle room that they needed in order to pay out. So I'm not aware of insurance companies actually asking to see terms and conditions, but I'm sure if they weren't in place, an insurance company would use that as potential wriggle room to get out of payment on an insurance claim.
Yeah, because I've sometimes wondered when doing limitation of liability clauses, one of the arguments for limiting your liability can be that there's a limit to your insurance cover.
Yes.
I wondered whether that might be affected by, you know, whether the insurers will actually choose the limit of the cover they'll give by reference to what you have in your terms. It's a bit chicken and egg, really. Yeah,
and quite often that is one of the negotiating tools that's used by the other side, which is, oh, well, you've got insurance up to 5 million, why don't you just offer 5 million cover? And there is, you know, an argument that you're paying for that insurance, so why don't you go up to the level of your insurance cover? But I still am sometimes a little hesitant about offering that up immediately, because, you know, it's almost like you might have insurance for your car, but you're not going to go and leave your car unattended with the keys in the ignition and the door unlocked. You know, you're going to take certain precautions to try and minimize the risk of theft. And similarly, I think insurance companies would still like to see you doing what you can to minimize your exposure and not immediately offer up the full extent of your liability cover. But there is that school of thought, and there's nothing wrong with it, that if you're paying for it, go up to the maximum of your cover. But I still tend to try and hold back a little bit on what will, you know, if we've got the negotiating power, to try and pull back a little bit on offering limitation caps that are up to the full extent of the insurance cover.
Yeah. Okay. Thank you.
Any other questions for anybody? My goodness, are we going to wrap up early?
We are, I think. Thank you everyone who's joined in and listened and participated. We will send round the slides afterwards, so you've just got a little note of what Rebecca's talked about, and please feel free to contact Rebecca if you've got any other questions.
Thank you everybody for joining us.
Thank you.
Thank you. Have a great day, everybody.
Thank you.
Thank you.
Bye-bye. Bye.